Good morning and welcome. This is Tyler Crone with the Thundering 36. We are so delighted to be interviewing Colleen Melody, who is running to retain her seat on the Washington State Supreme Court. Welcome, Colleen.
Hi. So it's a pleasure to be with you. And I was appointed by Governor Ferguson in January. So I've been serving you and the state of Washington for 4 months. And I'm running to retain my seat after being a civil rights lawyer for my entire career. So I started my career at the U.S. Department of Justice, where I brought cases all over the country, primarily in enforcing the rights of people to live without discrimination in the communities of their choice. I brought housing rights cases. And then in 2015, I came back home to Washington, where I'm from. I'm a Spokane girl, and built the Civil Rights Division at the Attorney General's office myself. I was the first employee there, and at the time I left it in January, I'm proud to tell you there were 35 attorneys, investigators, and staff working all over the state in every corner of the state to enforce Washingtonians' rights to work, live, go to school, play, and participate in their communities free from discrimination and bias. And that work taught me a great deal about the importance of state courts. I've litigated cases in 20 counties, everywhere from the peninsula to the Palouse, and really came to understand how important it was to enforce state law in state courts in front of state juries. And so, at a time now where the rule of law is being threatened, when the credibility of institutions is under attack, I decided to seek appointment because I want to put my energy, my skills, and my time sort of where my mouth is, which is that state courts are important. They're the backbone of our democracy, and they're the primary place where we enforce our state rights, which are different, broader, and better than federal rights in many respects. And so I'm very focused on Washington, its values, and its legal protections in this moment, and that's why I'm seeking to retain my seat.
Thank you so much. I think Anita is going to be asking our first question. Anita?
How would you approach cases asking to overturn long-standing judicial precedents, especially for cases that were decided long ago when Washington state looked differently than it does now?
Sure. So, I mean, stare decisis, as you know and will have heard from every candidate who you've interviewed, is really important to the stability, credibility, and predictability of the law. It is the foundation of the American legal system. And so predictable rulings are important. And there's a there's a portion of judicial humility that comes with that, respecting the decisions that came before. The other side of the coin of judicial humility is being able to say when you were wrong and when things have changed, and to be able to acknowledge that the judiciary has made a mistake. And in Washington, the standard for overruling a precedent is that the precedent is both harmful and incorrect. Harmful does all the lifting in that standard, right? Because we wouldn't even be talking about overruling something if it wasn't incorrect. And when we think about harmful, I think your question is an important one. The long ago and when the state looked differently, if we have data, experience, and understanding about how a precedent is harming Washington's sort of values, its people, we need to acknowledge that and kind of, stare it straight in the face. And I'll give you an example that I gave at a forum a couple weeks ago, which is a case that where the Washington Supreme Court upheld the right of a cemetery to refuse to bury a black baby who had died, and the parents wanted to buy a burial plot in the cemetery. And the cemetery refused on separate but equal grounds, and the Supreme Court said, yes, we agree with that. And so this grieving family is refused the right to bury their own toddler in the cemetery that they chose. And that precedent was overruled. It does nothing to support the sort of credibility or stability of institutions to sort of stand by that when it's both wrong, harmful, and disgusting. And so I think that it's a complex question, but it's never one-sided.
Thank you so much. I believe Ricky is going to try to ask our next question, having some audio difficulties, so we'll see if Ricky can do it. Otherwise, we'll go back to Anita. Ricky? Given that we can't hear Ricky, I'm going to pass it back to you, Anita.
Artificial intelligence or AI is not always a well-defined or understood term. How do you define AI and how do you think the court should approach using AI in day-to-day operations?
So I define AI as sort of machine-based systems that do things, whether that be write, analyze, or problem solve, that we would typically expect a human to do. And how I think the court should use it is carefully and straight ahead. It's not it's not appropriate or helpful to sort of hide from it. And there's a generational shift happening in I think in law and then in the judiciary in particular, some of the people who I talk to, including some of my peers, have an approach of just sort of ignoring it or banning it, wanting to do that. That's not going to happen. People are using it every day to do things like understand their family law rights. Civil litigants do not have access to lawyers, and we are seeing nothing but submissions from pro se people that rely on AI. So I think the court's job is to understand it, become expert, and regulate it because that way we're going to have better information about what it's doing, what its upsides are, and what its downsides are. So the court just passed on Thursday of last week an internal AI use guidance that I participated heavily in. I use AI to help do things that are not deciding cases. So when I have to go speak, I'll use it to help me create a PowerPoint. I put the text of what I'm going to do in it and then have it create my slides for me. And I also make sure that we're never overusing it to do things that really require human judgment, empathy, compassion, and review. The other thing is that the court has a pilot project to allow companies to consider proposing things that are AI assisted. We're currently reviewing a proposal for a will AI tool that helps people who are otherwise going to probably die and test it, right? Because wills are expensive, to use software to help them walk through that process. And that's an example of a way that it might benefit us.
Thank you. I'm going to have Anita ask our next question.
The Harvard Crimson recently reported on an emerging two-track clerkship system aligned on ideological grounds with a distinctly different path to clerk for liberal versus conservative judges. How does ideological alignment impact the work of a judge, and how can we create and protect a nonpartisan bench? Since electing judges is an inherently political endeavor, how do we ensure that judicial races do not become de facto partisan?
I appreciate this question. I think about this a lot. The Harvard example that you give, I find dispiriting and sort of a letdown in terms of what we've seen more broadly of institutions instead of meeting the moment, sort of giving into the moment. That there should not be liberal judges and conservative judges in that way. And so Harvard sort of taking this tack, I think sort of belies its responsibility that we've seen from so many institutions, from universities to law firms to others, of sort of agreeing to be complicit in what is a kind of a coarsening of the discourse and a lack of commitment to sort of making institutions what they should be. So I'll set that aside. I find it disappointing. Um, the nonpartisan nature of these races is critical. It is just the case that we must decide cases based on the facts in front of us and the law in front of us without sort of bending to the interests of the parties before us. And I'm very concerned about the path that Wisconsin and Pennsylvania and other states have taken where the races have become de facto partisan. I think that we in Washington owe each other something better, which is to really invest in civic education and understanding about how courts are different and that they are not a political branch. And, I do this all the time. My schedule is filled with events at the Rotary and the high school and civic groups in all corners of the state because I'm really committed to this idea that we don't demean the credibility and worsen what is already a very difficult discourse by kind of giving in the way that Harvard has.
Thank you. Our final question, prepared question, I'll also ask Anita to read it just for efficiency's sake, and then we'll go to follow ups. Over to you, Anita.
Tell us a little bit about the continuing education requirements for judges, and how do you proactively seek out furthering your knowledge and understanding of bias, diversity, inclusion, and accessibility? How have you applied these to your work?
Sure. So, I mean, the continuing education requirements for judges is 45 hours every 3 years, and that's not remotely enough. Um, I'm pretty active already in traveling around the state to help educate courts on how to respond to if federal immigration enforcement officials show up at the courthouse. We have a plan. We're doing tabletop exercises and kind of like practicing with the judges because just like anything else, you don't want to do it the first time for real. You want to practice. And so I'm doing that with Judge Diaz, Chief Justice Stevens, and some staff from the Administrative Office of the courts. In terms of bias, diversity, inclusion, and belonging, which I would add to your question, I'm doing that both on the personnel committee because we owe our staff in the courts an inclusive, respectful, dignified, and lawful workplace. But also with the judges to sort of, it's a decentralized court system, and every judge is an independent elected, and they know that. And so there's a task of sort of persuasion more than direction at the statewide level of getting judges to really understand how to treat with respect and dignity people who come before them who come from a different racial or ethnic background, who use an interpreter, who how to teach judges to both ask for and then respect the names and pronouns of the people who appear before them, people with disabilities and the accommodations that we both need to proactively provide and then look for opportunities to improve access in the court. And so all of those things are, so I'll be the incoming chair of the personnel committee after Justice Montoya Lewis retires. And these are things that I'm working on sort of every day, all the time, because it's a major focus of mine.
Thank you so much for such a thoughtful interview. We'll now see if there are follow up questions from our members who are in our meeting room today. And then before we close down, we'll provide you an opportunity to share final thoughts with us. Are there any follow up questions? I see your hand, Anita.
Sorry. What do you look for in a clerk?
Oh, so I look for somebody whose perspective is different than mine. So, the last thing that I want to do is hire somebody who already thinks or, has experiences that are similar to my own. The best thing I can do is find somebody who thinks and has lived a life that is different than mine. And my clerks are fabulous in that regard. They expand my thinking, they challenge me. And my last interview question when I interview a clerk is, would you disagree with me and how would you approach that? And there were people who answered that question that said, well, you're the judge, and so no, and I would always try to seek to support your reasoning. And they didn't get the job. The people who got the job were the people who said, I would do it respectfully and voraciously because that we're going to see around corners better. We're going to anticipate the results. I'm really a pragmatic thinker, and they're going to help me understand the impacts of our rulings and make sure that we've accounted for them.
I loved that question. Any more follow up questions from our members? Seeing no more hands popping up, we'd love to provide you the opportunity. You could take up to a few minutes, or it could just even be shorter to share some concluding thoughts with us, Colleen. And thank you so much for being here with us today.
Yeah, well, I appreciate it. It's Saturday morning, and here you are kind of doing the groundwork that is going to be necessary in just sort of communities around the state as we prepare people to understand the stakes of this election. Because there are five Supreme Court seats on the ballot, and it really is an inflection point for our state. We are undergoing, as we sort of talked about, a generational change on the Washington Supreme Court. And I'm really hoping that not only I retain my seat, but that I'm joined by people who have an excellent work ethic, who are smart, who have great values, and are really, really keyed in on the special place that Washington is in this corner of the country. We have a constitution that's more than 100 years later than the federal constitution. We have laws that are being updated all the time to sort of understand and sort of provide protections for our community with our values, and our needs. And so I really am focused on all of that. And thank you for doing all this work that you're doing to help get that message out and help Washington, have the court that I think it deserves.
Thank you so much for being with us today. This concludes the formal part of our interview, and we'll stop recording.